In this short lecture, we're going to be discussing the differences between coercion and undue influence. In case you have not already gone through my earlier lectures where I discussed coercion and undue influence separately, then you should do so now so that you can understand the importance of these differences. So the first difference, as we can see, is with regards to consent. When it comes to coercion, the consent is obtained by giving a threat of an offense or by committing an offense, whereas in undue influence, the consent is obtained by dominating the will of the other party. So in undue influence, there is neither any actual commitment of an offense nor is there any threat to commit an offense which forces you into entering the contract. It's simply about dominating the will of the other party. That is, the other party has in one way or the other influenced your own free will to enter into the contract. The next difference relates to the nature of the pressure, and this one is pretty simple. So in coercion, the pressure is of a physical nature, whereas in undue influence, the pressure involves moral pressure. The third one relates to the relationship between the parties. So in coercion, the parties to the contract may or may not be related to each other, whereas in undue influence, the parties to the contract are related to each other under some sort of a relationship. And once again, this should be pretty easy to remember and understand, because if you remember, in undue influence is about dominating the will of the other, and it's only possible to influence the other person's will where you are under some sort of a relationship, right? The fourth difference is about the reason. So in coercion, the reason is usually, that is, the party who is applying coercion, the reason is usually to compel the other person to enter into the contract, that is, to force another person to enter into the contract, whereas in undue influence, the objective, that is, the reason behind applying that undue influence, is usually simply to obtain an unfair advantage. The fifth difference relates to criminal liability. So in coercion, criminal liability is going to be incurred, therefore coercion is considered as illegal, whereas in undue influence, criminal liability is not incurred. So the sixth difference relates to whom the pressure is applied on, because we obviously know that in both coercion and undue influence, the pressure is going to be applied on somebody, right? So who that somebody can be or cannot be is basically the point of this difference. So when it comes to coercion, coercion may be employed even on a stranger, whereas undue influence may only be employed on the party whose consent is desired. So let me give you an example to explain what I mean to say when I say that coercion may be employed even on a stranger, somebody who is not necessarily a party to the contract. As always, looking at an example is going to make it much easier to understand. So in the first example, we see that there is a person named Amir who threatens to kill Saima, who is Basit's daughter. And basically, Amir is threatening to kill Saima, that is Basit's daughter, if Basit refuses to sell his house to him. So obviously, Basit does not want his daughter to be killed, so he agrees to sell his house to Amir. Now you see that Saima is obviously not a party to the contract, but this is irrelevant because Basit's consent to sell his house to Amir has been obtained on the basis of coercion. This is basically what I meant to say when I said that coercion may be exercised from any person and it may be directed against any person, even if that person is a stranger to the contract. And when I say stranger to the contract, I simply mean to say that he or she is not a party to the contract. So in our first example, Saima was not a party to the contract. Okay, let's quickly look at the second example. Here there is a person named Asif who threatens to kill Babar if Babar refuses to sell his house to Salman. In this situation, Babar is himself, of course, a party to the contract. However, when Babar agrees to sell his house to Salman, this is because Babar's consent has been obtained by coercion, and this is irrelevant that Asif himself is not a party to the contract. What matters is that his consent to sell his house to Salman was obtained on the basis of coercion by Asif, and the fact that Asif is not a party to the contract is irrelevant. And this second example, by the way, was relevant not to point number 6, which was regarding on whom the pressure is being applied, but is instead relevant to point number 7, that is, by whom is the pressure being applied. So in point number 7, we can see that when it comes to coercion, the pressure can be exercised by a stranger to the contract, as we saw in the example regarding Asif. Whereas when it comes to undue influence, the pressure can only be exercised by a party to the contract and not by a stranger. Okay, so now let's look at the 8th and 9th difference between coercion and undue influence. Okay, so the 8th difference relates to the onus of proof, that is, on whom does the burden of proof lie? Well, in cases of coercion, the onus of proof is on the party who wants to relieve himself of the consequences of coercion, that is, the party who wants to avoid the contract has the burden of proving that he or she was coerced into entering into the contract. On the other hand, when it comes to undue influence, the onus of proof is now on the party who is in a position to dominate the will of the other party, that is, the person who is in a position to be able to dominate the other party's will has to prove that he or she, despite being in a position to dominate the will of the other party, did not actually do so. So the person who is in a stronger position, that is, the person who is in a position to dominate, has to prove that the presumption is rebutted. Why? Because the normal presumption is that the party who is in a stronger position is going to dominate the will of the weaker party. So the person who is saying that no, this presumption did not exist in that particular case has the responsibility, has the burden to rebut the presumption and show that the party who is apparently the weaker party actually entered into the contract on the basis of their free will and he or she was not unduly influenced. So in the eyes of the law, there are certain relationships where this presumption will be held. So a few examples of relationships where one party is presumed to be stronger than the other party and is therefore presumed to be in a position to dominate the other party is, for example, that of father and son, guardian and minor, employer and employee, trustee and beneficiary, teacher and student, doctor and patient, solicitor and client, fiancé and fiancée, and last but not the least, any contract that is entered by or with a Pardanashi lady. So in all of these relationships, the law is going to presume the presence of undue influence, and the burden, I repeat, is on the party who is the stronger party and is in a position to dominate the will of the other party. That is, he or she has to rebut the presumption, and this presumption can of course be rebutted by showing, for example, that the dominant party had indeed made a full disclosure of all the facts to the weaker party before making the contract, and that the price was adequate, and that the weaker party was in receipt of competent independent advice before entering into the contract. Please note that I deliberately placed emphasis on "and" each time I said that, because all three of these have to be satisfied. So let's quickly look at an example where all three of these conditions were present, so that despite the presence of the presumption was rebutted successfully. So let's say that there is a teacher named A who has sold his property to his student named B. Later, B files a suit to cancel this transaction. Remember that the burden is going to lie on whom? Well, obviously A, because A is the one who is presumed to be in a dominant position. That is, A is the stronger party here and B is the weaker party. And since this is a case of undue influence, so the burden of proof is going to lie on A. And what exactly do we mean that the burden lies on A? Well, we simply mean to say that the burden to disprove, that is, the burden of showing that the presumption can be rebutted in this particular case, is going to lie on A and not on B. So basically, the weaker party doesn't have to do anything. He or she just has to file a case, and then the burden is going to be on the stronger party to show that there was no undue influence and that the other party has entered into the contract based on their free will. So like I said earlier, three conditions have to be satisfied. So let's see what happens later on in this example. What happens is that A, the teacher, shows that he had provided complete facts relating to the property to B, that is the student, and the price was market based, and further that B had obtained advice from property dealers of his choice before finalizing the contract. So in this case, the court is going to say that the contract is indeed valid because the consent was not caused by undue influence. Okay, finally, let's move on to the ninth difference, which relates to the restoration of benefit. As far as coercion is concerned, the aggrieved party has to restore the benefit that they have received, whereas in the case of undue influence, the party who is avoiding the contract may or may not restore the benefit. That's the end of this video, and we are done discussing the 9 differences between coercion and undue influence.